Sale of Goods Act. Sale of Goods Act. When a contract of sale of goods is where the seller transfers the goods to the buyer or promises to transfer the goods to the buyer for a price. Where the seller either transfers the goods or promises to transfer the goods to the buyer for a price. That contract is known as the contract of sale of goods. Now, what are the important features you gather from this definition itself? And this definition is given under section 4 of the Sales of Goods Act. So from the definition which is given under section 4 of the Sales of Goods Act, what do you gather? The important features to gather is that there has to be a buyer who is defined under section 2 subclause 1 of the Sales of Goods Act. The buyer is defined under section 2 subclause 1 of the Sales of Goods Act. There has to be a seller who is defined under section 2 subclause 13 of the Sales of Goods Act. 2:13 within subclause 13. Buyer is 2 subclause 1. And what is being transacted? Goods, which is defined under section 2 subclause 7 of the Sales of Goods Act. Right? So there has to be buyer, there has to be seller, and there has to be a price. There has to be goods. Goods defined under section 2 subclause 7, buyer defined under section 2 subclause 1, seller defined under section 2 subclause 13. This transaction, this transfer of goods or promise of transfer of goods be for a price. The price is dealt under section 9 and 10 of the Sales of Goods Act. Right? So, please understand. Two features. What is the meaning of transfer? Instant delivery on the receipt of the price. From seller to buyer, instant delivery of goods on the receipt of price is transfers the goods. And the second feature, promises to transfer or agrees to transfer, is a futuristic connotation that those goods delivery and transfer is deferred for a future time. Now, because of this definition comprising both aspects, the instant transfer as well as the deferred transfer, creates some complications. कैसे complications? कि I promised to transfer goods to you on a future date, but before that execution, the goods are destroyed. Who's responsible? Because the contract has been entered. Transfer. So that, suppose if those goods are destroyed which were under the contract, who is responsible? Seller is responsible or the buyer is responsible?
If the goods are with the buyer, then the buyer is responsible. But if it's still in possession of the seller, then
What if it is in transit? Because they are deferred date of delivery.
the seller.
Given the time of contract.
Exactly. Here it is. Here lies the answer. Depends on the facts of the case. So the answer lies on to the basis of each facts of the case. Partially Shreya was right. When the goods have not left the possession of the buyer, but of the seller, then the seller is responsible. But if the contract says that once it is out of my possession and in the transit, then there are two possibilities. Either the transporter is responsible or the buyer is responsible. If transporter transports with an undertaking of an insurance, then the transporter or the insurer is responsible. But where there is no insurance and the transporter says that this is not my responsibility if the goods are damaged, then the buyer is responsible. Or sometimes the seller promises to deliver at the doorstep of the buyer. So in that of the buyer. So in that case, up to the doorstep, the seller is responsible. And when you go into the international transactions, these are commonly used transactions where bill of lading, whether the transaction is on the basis of bill of lading, that means till the goods are loaded onto the ship, the seller is responsible. Once the goods are loaded onto the ship, then he is free. Then either the ship is responsible or the buyer is responsible. But if the international transaction says, we shall supply you at your doorstep, then the seller is responsible till that. Once the delivery is done, and if the goods are destroyed, can the buyer prohibit payments or stop payments? No, because then it is his responsibility. So please understand, the delivery of the goods plays a vital role. The transfer has two aspects: instant transfer and deferred transfer. Right? But ultimately it's the delivery which clarifies the position.
Sir,
Yes.
supposing
Another important aspect to remember is that there are certain features into the Sales of Goods Act. A very important feature is condition and warranty. Condition and warranty. Now what is condition and what is warranty? Section 12(2) and 12 subclause 3 defines condition and warranty respectively. Condition is essential to contract. Something which is essential to contract is condition. And what is collateral to the main contract is warranty. Essential aspect is condition, collateral aspect is warranty. The consequences also differ. If the contract of sale of goods have an element of condition, then if the condition fails, the result is performance of the contract afresh. But if the warranty fails, the entitlement is not the performance of the contract afresh, but damages. So please understand these two different situations and two different consequences. Jennifer, condition fails, result is performance afresh. Warranty fails, result is entitlement for damages. Is that clear? Condition and warranty. Now, another important feature of the Sales of Goods Act, which I've just explained you, is transfer. Transfer of goods, which is totally dependent on each fact of the case I just explained. But these are important features, so don't forget. The third feature is performance. That the performance of the Sales of Goods Act defines the stage of the performance, that when the Sale of Good Act contract will be considered to be performed. It will be considered to be performed only after delivery of goods and payment of consideration. Performance is over with two features: delivery of goods and payment of consideration. If either of the feature is lacking, the performance is incomplete. Is that clear? Now one more thing, important feature is the price. How will you determine the price of the goods? Sometimes the price is valued already by the seller. Then that is called the determined price. Sometimes the price is subject to valuation, where there is no fixed price, which is subject to valuation. Then, unless there is a valuation, there cannot be a determined price. So the law says that in such case, there are three important steps. First, that the goods must be valued by an independent valuer. The goods must be valued by an independent valuer. And without valuation, the contract is void. Without valuation, the contract is void. The second aspect is that in case before valuation, the buyer consumes the goods, what is the result? Before valuation, there is a consumption. Then he has to pay a reasonable price. Law says he has to pay a reasonable price, because the goods are not valued. So that should be, the payment must, because the goods are already consumed. So the payment should be reasonable. And the third condition is where the valuer is prohibited to value, then what? He is obstructed from valuing it. Then whoever is obstructing is liable to pay damages. Is that clear? Now, if you notice, all these provisions are matter of common sense. So please don't take this subject as a burden on your head. These are matter of common sense. And if you are confused with a question, pause for a moment, close your eyes, apply your common sense, and lo and behold, the answer will be right. So feel that confidence inside you. There is nothing to worry or nothing to fear. That completes your sales of goods. Oh, one thing, sorry. One more feature which is left, and that is called an entity called unpaid seller. Unpaid seller. Who's unpaid seller? The person who has already delivered the goods and has not received the consideration is the one who is known as unpaid seller. Now, what are the rights of unpaid seller? Again, it depends on the type of the contract. Suppose he has already entered into a contract of sale but not paid the price, and goods are still in his custody. So the common sense says that you need not to deliver. To withhold the goods is the first right of an unpaid seller. अतुल, क्या राइट है? पेमेंट नहीं आया, माल नहीं मिलेगा. Withhold the goods if the goods are not delivered. If the goods are already moved and are in transit, the second right of an unpaid seller is to stop it in the transit. The second right of unpaid seller is to stop the goods in transit. Right? And if the goods are already delivered, the right to sue for the price. In addition to that, the right to sue for damages and also for costs. What is the difference between damages and costs? Cost is the cost incurred for suing the person. That is called costs, not cost. Cost and costs are different. Costs is the loss suffered for suing the person. It's like I am to undergo this hurdle of moving the court for receiving my own money. So if I'm entitled to recover rupees 100 from you, I have to spend 25 in the courts to get 100. That means actually I'm getting 75. So who will pay for that? The balance. That is called costs. Got it? And damages is the compensation to revive myself to the position which I was in. You have caused disturbance in my mind, isn't it? जो मैं डिस्टर्ब हुआ, जो मुझे मेंटल ट्रॉमा हुआ, जो मुझे धक्का वाटला, उसका कौन खामियाजा भुगतेगा? हाँ? I came into business to do a smooth business. You are the one who's creating these hurdles and obstructions. कई दिन तक मुझे नींद नहीं आई, मेरे पैसे मिलेंगे कि नहीं मिलेंगे, मिलेंगे कि नहीं मिलेंगे. ये जो नींद नहीं आई, उसके वजह से सुबह मेरी परफॉर्मेंस में अफेक्ट हुआ, क्योंकि रात में नींद नहीं आई, दिन भर में सो रहा था. मेरा मैटर कॉल आउट हुआ, और जज साहब ने देख लिया, अरे वकील साहब तो सो रहे, कितनी रेपुटेशन को नुकसान पहुंचा। ये सब कंपेंसेशन इज कॉल्ड डैमेजेस। ठीक है, नाउ मूव ऑन टू पार्टनरशिप। यस, हाँ, ये तो बड़ा महत्वपूर्ण क्वेश्चन है। Who will decide the reasonability? Reasonability is decided by few factors. That what first factor is that what can be commonly understood by a person of a normal prudence. First factor, what can be understood at the right price by the person of a normal prudence. जैसे अगर मैं रसगुल्ला खाने जाऊं और बिल दे दे को मुझे 500 रुपए का, तो विल इट बी रीजनेबल? नहीं। 5 रुपए का देगा तो रीजनेबल, लेकिन 5 का नहीं मिलता। जिस जमाने में हम खाते थे तब 5 का मिलता था, अब क्या जाने कितने का हो, अब 50 का हो। लो, रीजनेबल। पता चला संजय? नॉर्मल प्रूडेंस से रसगुल्ला 50 तक ही होना चाहिए, 500 का तो अनरीजनेबल है। दैट इज द फर्स्ट फैक्टर टू गेज रीजनेबिलिटी। द सेकेंड फैक्टर इज द कस्टम्स एंड द ट्रेडिशंस ऑफ द मार्केट, कि नॉर्मली ये प्रोडक्ट किस वैल्यूएशन पर ट्रांजैक्ट होता है। So the second factor to gauge reasonability is the custom tradition of the market. Does that answers your question? All right.